Welcome to On the Chain. This is Jeff here with co-host Chip. What is going on, everyone? What's going on, Chip? Man, tonight we have an amazing guest with us. This is going to be a real surprise for everybody out there. We did hint that we're bringing on an attorney to talk a little bit about things that involve, oh, you guessed it, the SEC v. Ripple case. And actually, our guest tonight, and Chip, I'm gonna introduce who we're bringing on here.
Sure.
His name is Carl Cecere, attorney at law from Cecere PC. And what is so unique about Mr. Cecere, about Carl, is that has filed a motion to intervene on behalf of Roslyn Layton. And you guys know Roslyn Layton because we review Roslyn Layton's articles. And we're going to dig into this. This is going to be an outstanding conversation tonight. Chip, if you're ready to kick this thing off, we got to get to it.
Let's go, guys.
Welcome to On the Chain.
Welcome, everybody, down the chain. Guys, you know the drill. Go ahead and drop where you're from, the country, the city. Drop it in there. We'll post it as we talk. But without further ado, we'd love to bring in Carl Cecere, extraordinary attorney with an incredible amount of valuable insights. Already had so much fun in the pre-interview. So, Carl, welcome to On the Chain. Great to have you here with us.
Greetings, and thank y'all very much for having me.
Yeah, it's good to have you. And you're hailing from, did you say Texas?
Yeah, I'm in Dallas.
The great state of Texas, to talking to two gents from the great state of Florida. Two freest states in the union, as some would see it.
That's right.
But I thought we'd just jump right into it. So, you know, this was pretty exciting. Recently, you had filed this motion to intervene on behalf of Roslyn Layton. Let's hear a little bit about your background. Tell us a little bit so, you know, audience can kind of understand kind of what you do and, you know, some of your experience, especially as it applies to Supreme Court and working in some other states. Love to hear about that.
Well, great. So I own my own law firm, and I do mostly appellate work, and I do a lot at the U.S. Supreme Court, and I work in the Courts of Appeals and do a lot in New York lately. So that's where the Ripple's happening in the Southern District of New York. So I do a lot of work there, and got involved in this case. And I do a lot of work in this realm of trying to get documents unsealed on behalf of newspapers and journalists so that they can use them in their work. And so, you know, we got interested in this case, and I got interested on behalf of Roslyn to get access to the Hinman speech documents. And I don't know, I imagine your listeners are all very familiar with what those are, but everybody doesn't know, then director of I always mess up his title, the former director of corporate finance, William Hinman. He gave a speech back in 2018, which is really the only public guidance that anyone at the SEC had ever given about whether or not crypto assets were going to be regulated as securities or not. And he strongly hinted there that one token, you know, Ethereum, would not be considered a security. But then he turns around in a few months later, and the SEC files suit against Ripple for being a security. And the differences between the two tokens are not exactly apparent. So, you know, Ripple sought the documents related to Hinman's speech, and they're kind of like comments from other people inside the SEC about what the speech, you know, whether the speech is good or, you know, whether different things needed to be said. We don't know exactly what they say because we've never seen them. But, you know, he got a lot of comments and internal feedback, I think, from like 60 different people inside the SEC before giving this speech. And he, you know, Ripple wanted to get those documents, and then for their defense, because one of the really important issues in the case is whether or not Ripple had fair notice that it might be violating the securities laws by not registering, registering its token as a security. And, you know, we're wondering whether or not people inside the SEC were saying, well, you know, this doesn't make a lot of sense. These lines that we're drawing in the speech don't make total sense, or maybe we need to give some more public guidance, or maybe we need to do formal rulemaking. I wouldn't be surprised at all to see those kinds of comments inside these documents related to this speech. And so we'd like to see that. We'd like to see if there was any confusion inside the SEC or concern inside the SEC. And so we'd like to have them released to the public. Like I said, Ripple's received them from the SEC, and they're actually using them in support of their motion for summary judgment. But we can't see the motion for summary judgment or the documents because they're all behind a sealing order from the court.
Yeah, I thought it might be. Hey, I was going to say, Jeff, I thought it might be helpful right here. I do have a little, just that snippet of the speech. So let's listen in here. So just how we can bring some context to what you just said there.
18, Hinman gave a high-profile speech declaring that Ethereum's digital token, Ether, is not a security.
We believe current offers and sales of Ether are not securities transactions.
The price of Ether immediately took off.
There, that was after the comments by the SEC. So interesting market action there, right? Whoa.
So there you go. Just
Whoa.
Yeah, whoa is right?
Yes.
That's like a hockey
Like a
stick right
rocket.
there. It's going up there.
Yeah, I mean, it's not exactly, to the people in the crypto community, it wasn't as if there wasn't a concern about whether the SEC was going to do anything in regulating crypto assets. But nobody had any guidance. Nobody knew anything about it. So yes, when you get a little clarity on Ether, that made it a lot more valuable. And there's also concerns because people inside the SEC, including Hinman, had relationships through their law firms that they worked at in the private sector with Ether and Ethereum. And so, there's concerns that there's a little bit of inside dealing for a favored token over rivals like XRP, who have a little less favored status and were kind of fast followers that are really coming on the scene.
Could you say at minimum there's a conflict of interest? And
I mean, I would probably say that there was a conflict of interest on some level. Yeah, certainly among some people at the SEC.
Yeah, and
Yes.
it seems like as you're kind of referencing and the things that you've worked on at the Supreme Court level, and in general with these types of cases that kind of deal with and in and around these administrative bureaucrats, or trying to gain access to certain files, it seems like this isn't a unique case that you have an agency that's trying to hold back documents. But it just seems also, a little bit difficult for all of those that are, heavily, invested in the crypto space to see that the agency is trying to manipulate the outcome, trying to pick winners from losers. But again, doesn't seem to be a new narrative. What have you seen, in reference to what you're seeing with this case, experience that you've had previously, kind of walking into a case that, obviously different subject matter, but, similar type of scenario?
So, I mean, I've been involved in a lot of different sealing fights, and I've actually been involved in a number of cases under the Freedom of Information Act, which is an act enacted by Congress back in the 70s, precisely over concerns about this kind of thing, that a lot of agency decisions were happening behind closed doors, and they made, a lot of decisions that really impact the American people without a lot of transparency to the American people. And the irony of the Freedom of Information Act is you're basically allowed to go and walk to the SEC offices and say, give me these documents. And there's only a very limited set of things that the SEC can say, by which they can hold these things back. So, and I know that there are a lot of people who are pursuing the Hinman speech documents from the SEC directly. My understanding is that they've been kind of balking at the free release of those documents through that avenue, but it kind of shows you what Congress expects to be happening in these kinds of fights. That is to say, Congress expects that we should be able to see what our people are doing. These are our employees; they work for us, and there are only a limited set of circumstances in which they shouldn't be. What they're talking about internally shouldn't be shared externally with the American people. And it's really important for journalists like Ms. Layton to be able to have them. So, there's a tension. The agency, sometimes they got legitimate reasons for not wanting to disclose policy before it's fully implemented. But like the policy of FOIA and the policy of, interventions like mine is that generally the presumption ought to be in favor of disclosure. They ought to make these things available to the public, and they're going to have some really compelling reason why not to, it's not an uncommon thing for them to try and keep secrecy, but it's not good, I think, generally for them to be doing these things behind closed doors.
Right. So what's the next step on this right to intervene? What does that look like? So you've already filed this. What's that next step? I mean, what happens next?
So we're not entirely sure what Judge Torres is going to do. She's had when I told you earlier, we had the initial fight over whether the SEC had to disclose these documents to Ripple. Mm-hmm. And when that happened, they referred Judge Torres referred that fight down to a magistrate judge who kind of did her own level of fact finding and then determined that they needed to be disclosed to her. I wouldn't necessarily be surprised if this fight also gets referred back down to the magistrate, especially because she's got the clearest sense of the arguments about what these documents are. She's actually looked at them. There's a process. It's poorly named because it's Latin, but it's called in camera. But it's when the court takes the documents that are subject of a fight over privilege or something like that and looks at the documents themselves. And it's a little bit weird because the privileges that the SEC is asserting are meant to protect the documents from seeing by anybody, but there's kind of an exception for courts. We kind of have to look at these documents in order to tell you whether that they should be disclosed. So the magistrate judge has already done a look at these documents in terms of the privilege fights and whether they ought to be disclosed to Ripple. So we'll not necessarily be surprised to get them referred down to the magistrate level and get her input. But that does mean it's not necessarily going to be fast decision. We're at some point they're going to rule on whether or not we are entitled to intervene as parties in this case, really only for a limited purpose of this ceiling fight. But Roslyn would be a party to the case. She'd be an intervener, and she'd have certain rights there too. And then the court will decide whether or not the documents need to be released to the public. And there may be some fight over some redaction or something like that. They may try and hold back some level of information. We don't really know. I don't necessarily think that anything should be held back because the magistrate judge and Judge Torres have already ruled that there's no privileges that would keep these things from being turned over. And so they ought to be turned over to the public as well.
That would be more of a stall tactic too. Just something else I want to pull up too. This one is Clayton basically giving some credence to what Bill Hinman disclosed. Because remember, they said they didn't do it in the capacity of the SEC. They did it it was a personal, and then that kind of boomerang back and forth. So they wanted to have it both ways. But this is a very short clip that I think kind of plays into the narrative here. So
falls within the ambit of a securities offer and sale is a facts and circumstances analysis, where we use a principles-based framework that has served American companies and investors well for over 80 years. Bill Hinman recently outlined the approach we take to evaluate whether a digital asset is a security, and I encourage you to take a look at Bill's speech, which is available on our website.
So that sounded like guidance to me, right? So you have the then chair of the SEC, Jay Clayton, telling an audience to refer back to what the SEC's opinion is on that. So as far as the speech itself, so it is guidance. And when we think about disclosure in this, I mean, they're going to go back and forth, and we have to redact it, but there's privilege stuff. So that we saw a lot of this sort of delay tactics. I mean, it was, I think 5, maybe 6 times, maybe, I don't know. Somebody can correct us, but I think it might've been 6 times, 5 or 6 times where the judge says, turn them over. Yeah. And it's amazing that, can you imagine if that had happened with Ripple, I mean, what would have happened? So this is a regulator that works on behalf, like you mentioned before, of the American people, right? With their chief mandate is to, facilitate capital formation. But the real important thing they're supposed to do is to protect the investor. And it seems like they're really doing a good job of protecting themselves. What are your thoughts about, what do you think the next steps are in this Ripple case? Someone had a great question here. They said, ask Carl, this is Guy. He said, ask Carl if he's ever seen a case like this, where there's 75,000 XRP holders. And, with John Deaton, I'm in behalf of that, and representing, us, some of us XRP holders. Have you seen anything like that before?
It's not uncommon for parties to get really, really interested in an instance in which an agency like the SEC makes a rulemaking. They make an official rule that, you get a lot of people. You'll definitely get 75,000 comments when the agency actually does something. I've never seen this level of interest in a piece of private litigation. You're just talking about, and it's not private litigation, it's the SEC, trying to do a regulatory action against Ripple, but it's just involving one private party. It's not a giant class action or anything like that. No, so I've never seen anything like that. And John Deaton and the XRP holders that he represents are really an interesting facet of this case that really make, it adds a really interesting wrinkle to it. I'm sure that's got an impact on the way that Judge Torres looks at the case. She's been clearly very interested in hearing from John and, in his investors, because I think she recognizes that it's not just about Ripple. And that's why so many people are interested, right? Like when they take an action against Ripple and they say that it might be a security and that every trade in a Ripple, in an XRP might be unlawful or subject to penalties. I mean, they're impacting people's livelihoods. People have put substantial portions of their fortunes into XRP, and now it's locked up. Now it's not available on the trading platforms. Now it's reduced in value significantly because of this cloud of uncertainty that's been put in place because of the SEC's ostensible efforts to protect those investors. It's very, very ironic. It's very strange. It's unprecedented to me to see that level of concern about just one securities offering in an SEC enforcement action and anything like this. Agency actions frequently get a lot of interest, but usually when they regulate an entire industry or something like that, not when they're doing one company.
And this is really, it is interesting, because we've asked John, Deaton the same types of questions. Have you ever run into anything like this? And it seems to be so punitive. And at this point, it seems like, when Chair Gensler came in and took over, he could have readjusted the direction that the case was going in. He could have taken a different approach. He chose not to. The case took on a life of its own, to where they didn't just, go after the private company Ripple, but even in reference to by some of the SEC attorneys, they went after and attacked XRP holders. And some of the statements that they'd made along the way was, that the XRP holders aren't technologically savvy enough to understand, or, there's different things that have been said, over the course. And I find, one of the things that Chip and I kind of, we go back and we try to figure out, which also seems, a little bizarre in timing. I don't know if you've ever seen anything like this before, but where Clayton, the day after he basically, the last action that he did as a sitting chair was file this lawsuit. So the lawsuit was filed. The next day he resigns and moves on. And obviously he was going to go out anyways. There was a changeover of administration, all of that. He leaves early, leaves a little bit of a gap in terms of, who the next chair would be. Changeover administration, Gensler steps in. But have you ever seen anything? It was very, very bizarre with that timing of it. And just kind of a final point to that, to get your feedback. It also seemed like the SEC was extremely unprepared for this lawsuit. They came at it as though they knew everything. And Gensler would say, oh, it's so clear. Everything's so clear. But yet they'd never seem to have all the facts. And they kept asking for postponement and delays. So I guess, starting with the Clayton thing, dropping this major lawsuit a day before he leaves, over to where we're at now. What have you ever seen anything unfold like that? And what is your feedback on it?
I mean, it's not uncommon for one administration to leave some trash on the desk for another administration. I mean, there's always a level of handoff in, between agencies and that kind of thing. So I wouldn't say that that's necessarily unprecedented. It's just a strange thing to be doing to make this your marquee case, right? This is the case that they've chosen. Of all of the issuers, they missed Frankfurt-Feed entirely, didn't regulate anything that he ever did, and took no interest at all.
Right.
And then they pick Ripple, and Ripple had, as far as I can tell, and I mean, I'm not an expert on Ripple, but they didn't have any sense that there was any fraud, that there was any, that there was any manipulation by Ripple of the XRP. Like they were concerned about their overall ties to their cryptocurrency, but there was not a whiff of fraud. And I think that's the really interesting thing, is to make this your marquee case when there's no abuse of the consumer going on, that anyone's concerned about. And you're going to make this the case that you're going to use as, we received no guidance from the agency under Clayton or under Gensler over whether or not, where is the dividing line. So I suppose that this case was meant to establish what the dividing line was meant to be, but I'm not going to know. Especially the way that the case has gone. It's gone so poorly for the SEC. It's not going to establish, I don't think, a bright line rule that they can regulate any cryptocurrency. That's not going to be the outcome of this case. And if that's what they want, it was like the broadest authority possible, then you're right. They were not prepared. They were just not ready for the blowback. They were not ready for the Ripple to make to take a stand against them. And they've been kind of playing catch up all the way through. And, it comes through these documents too, because like you said, initially they were just trying to portray this as a speech that Hinman gave in his private capacity. And then they started to try and call it guidance. And then they tried to hide it behind a deliberative principle, deliberative privilege. Like we were making agency policy when we were crafting this speech. So that's why we're not going to turn these documents over. Then they tried to try attorney-client privilege. Like, well, some of these people were SEC attorneys. So this was legal guidance that they were getting from them when they read the speech and gave their comments. It's sort of been like they should have had a policy and they should have stuck with the policy about what these things were and then stuck with it. But they didn't. They've kind of just been playing, been pulling out audibles the entire time throughout this case. And so, yeah, it's kind of surprising that they were going to make this their big piece and didn't really prepare.
Well said. When you say pulling audibles, that really defines it in a really succinct way. I think, could you talk a little bit about this recent filing that Ripple made based on the recent opinion by the Supreme Court and with regards to fair notice defense? Can you talk a little bit about that and what your thoughts are around that?
Sure. So do you have that filing available? Because I don't remember the name of the case.
I'll probably have to. We can probably pull it up in the interim here.
I think it's Birnbaum is the name of the case, but it's in a completely different context. It involves when you're supposed to disclose a transaction in an account over $10,000 to, I think, to the comptroller, and the facts of the case are completely different from this, and they don't have anything to do with the SEC. But it is interesting in that case that the fight in that case was you're supposed to do these reports periodically to the comptroller of the currency from the banks, and so it was kind of a question like, is it every time they get in trouble and have to pay a fine every time they don't report a transaction over $10,000, or every time they make a report like one of their quarterly reports that doesn't include that transaction. It was a huge fight over a really, esoteric thing about about the comptroller's regulations and the congressional rules that underlie them. But Justice Gorsuch took the opportunity in the case to sort of say, look, one of the problems with this kind of legislation and this kind of things that these agencies are trying to do. This was the Office of the Comptroller, not the SEC. But when agencies do these kinds of things, people don't have fair notice about them. So I think, and I wouldn't be surprised if this is something that Justice Gorsuch is picking up from reading the Wall Street Journal reports on the Ripple case. These are the kinds of things that percolate upward and get on their minds, and then they write about them. So I think it's really interesting and timely for Justice Gorsuch to be writing on the fair notice defense in a case that's so important about the fair notice defense. I think this is going to be one of the marquee cases about what you're entitled to have for fair notice, because I think there's virtually no notice in this case. And then again, you have the SEC now backing away from what little notice they actually gave, because what notice they gave was pretty darn confusing. So yeah, the case is Bittner. And like I said, it's about the Bank Secrecy Act, totally different context. But it's really important, I think, for the idea of fair notice. And one of the things that the conservatives on the court really care about, and what really matters with the 6-3 conservative majority on the court, is they really are very concerned with administrative overreach. They're really concerned that agencies wield a kind of unreviewable power in so many different instances that Congress hasn't done enough to rein in their power, and so the court has stepped in a little bit to sort of take away some of the agency's power. And one of the big concerns that they've always had with agency actions like this is that the agencies just can arbitrarily pick winners and losers and decide that they don't like these guys. And they know about the revolving door that brings the Claytons and the Hinmans back out into law firms with the very people that they were regulating. And that happens not only in the SEC, but that happens in a lot of different regulatory contexts. So they're worried about that. They're concerned with cases exactly like this. And so, this is really an interesting context as it goes up. And I mean, obviously the SEC is thinking about this, and Ripple is thinking about this as this case goes up. This case could go a long way, I think.
Exactly.
As we go towards, it's interesting. There's been within the community a lot of discussion over settlement, or the case goes the distance and gets some sort of judgment. And obviously, if there's judgment, then someone's filing, with the possibility this ends up at the Supreme Court. Do you see this where we're at now? It would just be interesting, as you're finally, you've seen things like this unfold before, but do you see this going to settlement, or is this going to judgment and then potentially ending up in the Supreme Court?
I mean, I think that in any big case like this, you kind of watch for certain touch points, in the procedural life of the case, the most important of which is, we're probably past, which was like the motion to dismiss stage. They didn't get the motion to dismiss. The SEC had asked to have the fair notice defense dismissed, and Judge Torres refused to do that. That was a big marker about what this case was going to end up being about if it ever went before a jury. The next big marker will obviously be the sealing fight and the summary judgment motions that have been filed and not yet ruled upon. I certainly don't see the SEC winning on summary judgment. You would kind of think if she was going to grant the fair notice defense that, if she's going to allow that's going to pretty much take you to a jury trial. You can't get out of it on a summary judgment kind of basis. So, I was a little surprised not to see more of a move towards settlement before summary judgment, knowing that the SEC was going to have to face this stuff in court. Maybe we get a little bit of a sense after the summary judgment rulings are ruled upon, probably denied, whether they're going to offer some kind of settlement. But I mean, if I'm the SEC, I would like to get out of this sooner rather than later, because I don't see it going well for them. And then I would think they would probably rather not have their authority under Howey tested at any higher level, right, because it would just result in some level of rollback over what they were enjoying now, and they would just prefer another kind of case.
Yeah, and also too. Go ahead.
No, I was going to follow up with that. It just seems like to get a settlement, you have to have some sort of meeting of the minds between the parties, and it just seems like they're so far apart from each other. All right.
Yeah, I
with
mean, you think about it from Ripple's point of view, they could either pay some giant fine that, if they admit anything like what the SEC is suggesting, that, you're talking about fines in the billions and billions of dollars that could have a huge effect on their viability of of their security, of their cryptocurrency. And I think that's got to be a big concern for them. And in their back pocket, they've got a potential slam dunk win. That is, you couldn't regulate us at all. Like, we are outside your purview, and we're outside of your purview forever. So your claws are never going to, you're never going to get your claws into us. That, to me, the incentive on Ripple's side is to go the distance and go very hard and not offer any kind of concession. And I don't know that they can give the SEC any kind of concession that gives them, the SEC, the kind of win that they can, announce in the newspapers to get anything out of it. So yeah, it seems to me their incentives are to fight, unless the battlefield of the case kind of changes.
I want to put this up here, but we had this question. It said that, well, actually a statement more or less, but the Department of Justice already declared XRP to be a currency and not a security in a 2015 settlement. And then between DOJ and Ripple Labs, but also you had a CFTC, which did also in 2015, 2016 timeframe, which also requested an audit for 5 years straight, right? So you have two, and I think a lot of times this is probably what the founders were most concerned about when they set up the country. They wanted gridlock. They wanted stuff to move slowly because they wanted a lot of angles to be saw. But what I probably didn't see was these crazy regulatory bodies. We have the CFTC, which regulates commodities. And at the same time, what is the SEC over here doing, calling everything, a security? So, because there was also that. So you've got two regulatory bodies, Department of Justice, CFTC, that have already interacted with Ripple. Then along comes, out of nowhere, comes the SEC saying pretty much everything. It's debatable whether they even think ETH is now. Gary Gensler has kind of been slippery slope around that as far as whether it is or not. But ultimately, I mean, is this troublesome as well? And also you have the, especially when you think about the Supreme Court case I think it was last June, which was the West Virginia versus the EPA, where the overreach with the EPA, getting the authority to regulate this, and they went outside of that and started making new rules and how they were thinking about it. What are your thoughts on those? Well,
I mean, it's not surprising to see the agencies fighting for turf in anything that's new, right? Crypto's a new thing. Everybody wants a piece of it. Everybody thinks that they know the right approach to handle it. Nobody's doing a great job. And nobody in either administration, either the Trump administration or the Biden administration, have shown any indication that they want to stop those fights. That's where the buck stops, is with the president. He's supposed to say, well, this agency is going to regulate this and this agency is not, and we're not going to be having turf wars over these sorts of things and over people's livelihoods. But we're finding instead that they've let this thing fester because I think no one quite sure what to do with it. Crypto raises a lot of concerns, but it also has a lot of upsides, and we don't even entirely know what those upsides are yet. And I think that's another problem, is that we don't know what the market's going to do with these things. So they're kind of in the middle of a giant, if it was a cartoon, it would be that giant, dust ball with people flying out of it. That's where we are. And we need to get out of it, at a certain point sooner rather than later, because it's really bad for everyone involved. And it doesn't put the focus in the right place, which is with the people who are actually abusing crypto holders. Those are the ones that need to be a bigger concern. And we're not doing enough on the front end to find those people and regulate those people. And we're getting in these distraction fights over, who gets to regulate this turf.
And a lot of that seems to be very purposeful. It seems to be that there's maybe an agenda or an initiative on behalf of some of the players, either within one of the bureaucratic administrators or one of the elected officials or a group of them. It seems that, they gave SBF, and you brought him up before, they gave him almost, favorable status. A guy that came out of nowhere, ramped up his company to all of a sudden being the talk of the town, but not just the talk of the town, but being the one that Congress decided to invite in to allow and give them guidance in the crypto space. Whereas you have all these other amazing CEOs that have been in tech, for decades, from Kraken, from Gemini, from Coinbase, and the list goes on and on. And somehow Congress, Maxine Waters and others, they just decided, we want SBF. He's their darling, this 30-year-old guy that, his company just ramped up in, 2 years, all of a sudden he became a major donor to, to the blue team. And that's the guy they decide. So it just seems like there was some orchestration, but that's also, I go back, step back to, why did they drop this big bomb on Ripple? Like you said, why do they want to hang their hat on this case? It just seems so odd, the whole thing, and the power moves. Why they're moving these pieces around the board, and it just seems like there's going to be massive blowback against them.
Yeah, I mean, I'm not an expert on Washington power politics. I can't help you there. That's just above my pay grade. I'm just a little lawyer.
Yeah.
No.
But yeah, I think that certainly these turf war fights are not good for all of those things, right? I mean, they create these opportunities for abuses all up and down the line. And yeah, it's also a concern when there are certain people who spend their money in the right places on lobbyists and get a free ride. And then the other people who are just trying to do the right thing and offer a good product to people end up in the crosshairs of the agencies that are supposed to be protecting them. I mean, I just think that, the Ripple case shows where a lot of things can go wrong really fast with agencies. And, this is going to be, by the way, a problem that we face when we get to the Supreme Court, because they're not up on technology and new things. Like, that's not where they spend their time. They're not invested in crypto. Like, that's not, none of the justices are doing that. That's not their, the way that they play in the world. And so, getting people to understand these things is hard. I think there's an uptake on crypto that's very hard for people to get. So you have a lot of people pretending they want to look sophisticated, so they talk about it, and maybe that causes them to listen to people who are really smooth and really slick and seem to be at all the right parties, rather than the people who are really knowledgeable and know what they're doing. I wouldn't be surprised if it's as much as just not knowing what's going on as much as it is actual conspiracies,
Yeah, they would, at the same point, I guess they're using case law and the Howey test outcome from 1946 and trying to figure out, how do you apply that to modern day technology, modern day companies? And, does it fit within the framework? Which is another one where, Gary Gensler only uses one little component of the test, doesn't look at the whole test. But as we look at all of this, all the power play, all these moves, everything that's happening, you filed a motion to intervene, and Guy brought up, this comment here. So on the Ripple side, you had the 14 formal amicus briefs were also submitted, all these different entities like the Chamber of Digital Commerce, TabChat, iRemit, etc. And then the action, with John Deaton, all these things are going on, and now you guys come in February 15th when you send, your motion to intervene. All of this stuff has to compile. Do you feel confident with your motion, with all those other things going on, that just seems like the judges, like you said earlier, the judges got to look at this and say, wow, I've never seen, there's just so much coming out against the SEC. The SEC is covering something up here. Do you feel confident that you're going to get an approval on the motion?
I think that we're going to get a good fair shake. I don't know that I can guarantee the right outcome. I think that we should win, but I know she's got Judge Torres has got other concerns as well. I mean, she's going to be
Right.
caring about the SEC's legitimate worries about these documents. I mean, she's been fair and she's been careful to them. But in a larger sense, I think that the nice thing about Judge Torres, from what I've seen throughout the case, is that she knows the eyes are on her. She knows the public importance of the case, and that's great, because I think that judges in these kinds of situations tend to go one of two ways. When there's a bunch of people jumping in on them, they either go, well, I'm the one with the certificate on the wall. That one's signed by the president. I'm going to be the one to make a decision. I don't care what any of you people think. And she has not given me the indication that she's that type of judge. And I think that's better for a better outcome in the case. I mean, obviously, I'm only involved in one small part of the case, but I think ours is an integral part of the case. And I think that if we are successful in getting these documents, it's going to put more pressure on the SEC to do something to moderate its stance in some way, or dismiss this case or something. I feel like it puts pressure on the agency, and I think puts it in the right way. I mean, I don't mean to suggest that pressure is illegitimate. That's what the people should be doing, is saying, hey, what are you doing and why are you doing it? And do you think this is really fair notice when we just can't tell the lines that you're drawing, and we just can't do this, and we want to know where we want to put our money, and we need to know some clear boundaries.
Right.
I think that those are really fair questions for the public to be asking them, and I think that the outcome of this fight is going to give them ammunition in that fight.
And then how does it feel that future law students will probably be reading about this case and everybody involved in it? I mean, this is such a major case for cryptocurrency in the U.S. and its outcome. I mean, just imagine, students, a couple years down the road going to law school, studying outcome of cryptocurrency, and this is going to be the central case that they study.
Yeah, I mean, you find in these boundary setting cases that this is where the law gets made, right? I mean, there really is no right answer right now about whether or not XRP is a security. There's really no right answer. And I think I say that because the agency's never said anything directly about whether it is. And the Supreme Court, when they get there, they're going to look back and they're going to look past Howey, right? Like we've been talking about the Howey test. This is not a court that is overly concerned about precedent from 1945 if it's not going to service the needs of this current problem. So they're going to look back and they say, well, we were talking about this earlier with West Virginia versus EPA. There is an overlay of a court that's very concerned about reining in administrative excesses, and West Virginia versus EPA is exactly where I think the rubber meets the road in this case, because that case turned on the adoption of the major questions doctrine. And that is a doctrine that says we're going to look past our old precedents about looking at, interpreting agency action and the SEC's regulatory authority. We're going to look to the text that Congress wrote in 1930. And the major questions doctrine says, if it's not clear from that text, from what Congress wrote, that the agency, authorized to implement the statute had the power to do the thing that they're trying to do, then they don't have the authority to do it, period. If it's not clear. So you can't take a vague test from a vague kind of statute that didn't even necessarily have the full regulatory regime of the SEC before it when it created the Securities Act. That puts a different kind of pressure on where the SEC is coming from. Like that really changes the dynamic, because you're not just reading the statute and saying, well, we have to accept whatever vague thing Congress said. We're going to say we're requiring Congress to be clear on this particular question. And the question, it's just not clear that they would regulate currencies as securities on the language that Congress wrote back in 1930s.
Right.
So that's really, really an important question too. And that's one of the reasons this case may go all the way.
probably go the distance. And I think, yeah, one other thing about the fair notice defense is that Ripple has been very public. As a company, they've been very transparent. They've been very transparent in a public way where even with the MoneyGram involvement, they went to the SEC and said, hey, we're going to do this. They didn't hear anything back. Every step they made and a lot of things that they did or invested in organizations and companies, you're talking over a span of 5, 6, 7 years, nothing. And I think that's going to also play very well into they just pull it up in court and say, look, we came to you guys and said, hey, we're doing this. At no time did you say, hey, this is something where, you shouldn't be doing this. There should be another way. Like there was no fair notice given at all. And just curious, you brought up the major questions doctrine. What are the origins of that? Like, how did that come to be? And why is that such a big deal when it comes to the Supreme Court?
So the major questions doctrine, it came out of the DC Circuit originally, because the DC Circuit is the circuit that hears a lot of challenges to agency actions, and it originated with a decision from Justice Roberts when he was Judge Roberts, and Justice Kavanaugh has also written on it when he was Judge Kavanaugh, and they were both on the DC Circuit. It hadn't been adopted until West Virginia versus EPA on the Supreme Court level, although you might look at some previous Supreme Court decisions and kind of find, what sounds a little bit like the major questions doctrine, but now they're calling it the major questions doctrine. Now they're outlining it and saying, no, this is explicitly the law. And it's now the law of interpreting agency enabling statutes. And, every agency, whatever action it takes, has got to find footing for its authority in something that Congress wrote. That's what agencies do. The agencies, they may be creatures of the executive. They work for the president, but the president can't tell them to do anything unless Congress has given them the authority to do it. So you look to a statute and say, can the agency tie what they're doing to the original statute? With West Virginia versus EPA, that's the first case to really officially adopt it, calling the major questions doctrine, demanding that we have this clarity in the old statutes, giving the agencies authority before they're going to be able to do things, but only in major questions. And there's a lot of really open questions about what the major questions doctrine really means. Like, what's a major question? How do you know? We know it's got something to do with dollars. If it affects industries, if it affects people economically in their daily lives in a major way, that's going to matter. It mattered in the West Virginia versus EPA case. That was about coal-fired power plants, and they found that EPA orders telling them to do their business differently. It's very complicated regulatory environment they're dealing with, but kind of requiring them to change their business, not just on one site, but in different areas of their business. That violated the major questions doctrine because they thought that the authority to regulate power plants was tied to the power plant. Emissions from power plants, point source for pollution is what they call it. That means you can regulate the point source, the source of the pollution, the power plant where it comes from, but not other parts of the business. That can have a huge impact in this case. But we don't know a lot about what the major questions doctrine means. It's also being tested in these student loan cases that are being argued this week at the court. The major question doctrine has been stretched and thought about and theorized over during oral argument because the justices have not figured out exactly how they want to use it and where the boundary lines are going to be drawn. This may be a case that helps to draw that as well when Ripple gets up there.
Yeah, it seems like we're finally in a point in time with a reference to these different major actions. We see from a political perspective, we seem to see a trend of an overreach, and that overreach gets settled in court. And it seems like from a politician's perspective, they look and said, well, let's do whatever we can do. Let's get away with it for a little while. It'll look really good for us. It'll look good for our voting base. And then when it gets thrown out in court, and the press will bury it on a back page someplace. But it just seems like at least we have trend right now within the court. And we saw there was another major court case that had to, do with, we don't want to get into but it was also, dismissed from a federal level and pushed back to the states. And that was a major, victory as far as, the Supreme Court said, look, we don't have, the federal government doesn't have the jurisdiction on this, but it's the state does, and so it's good to see that. It's good to see like the student loans finally, saying you guys far overreach your authority. You don't have that authority to do it. EPA, same thing. And it's gonna happen with the SEC. So here's a question, for you. I'm going to throw this one up. This came from Michael Gazillion. He was just saying, can you ask if this goes to the Supreme Court, how many years are we looking at here? If there's a outcome in a case now, then it goes to the Supreme Court. What does this look like at this point? Because obviously, if it goes to that level, there's also going to have to be some commentary on the SEC overreach, and this just seems to go on. The follow up to that is, can Ripple still operate even though it's going through this litigation for all this time? It could have a detrimental impact on a lot of things.
Yeah, I mean, I think that I would stock up on snacks. It's going to be a while before we get a definitive resolution of this case. You're talking about hopefully Judge Torres will rule on summary judgment rulings pretty soon, and then you have a jury trial relatively soon thereafter, at least on fair notice. And then you got to go up through the Second Circuit, and it's going to be a big case at the Second Circuit with a lot of involvement. That's not going to be a fast decision at that level, and then to the Supreme Court. So, I mean, I would put the timeline out at least 2 years before we get any definitive resolution from the courts. Now, I mean, that's what puts so much pressure on Ripple right now, because I can't even tell you, what they're actually doing. Are they actually, I know they're not issuing new XRP, but I mean, people are still trading in XRP on some platforms, as I understand it. That's going to continue to be going on, but it's going to be under a huge cloud the entire time. And, until something gets resolved, it's really, really hampering their business. I don't know what they can do in other aspects of their business at Ripple with this hanging over their heads. It's really, really hard for them to operate.
So it seems like it has detrimental impact on action here in the U.S., which it seems like Ripple's focus now seems to be anywhere but the U.S.
I mean, I think that if I'm Ripple, I would think about, working around in other countries to the best they can, while avoiding the United States, because they just don't want to create a bigger hairball.
So to somebody else brought in the chat, I can't find the exact question, but they talked about when John Deaton went in and intervened in the library case, where the judge and the SEC, the SEC actually admitted that secondary sales were, which they were arguing were not, subject to, were kind of out of the in the clear as far as that, and the SEC agreed to it. They're like, yeah, again, the judge even got them. So when something like that happens, does that have any major effect when you have the SEC agreeing with the judge saying, yeah, the secondary sales are not a security? Does that, because was that a circuit court? Where was that? That was was that Massachusetts or something, or maybe Connecticut? Where that was? Does that have any big overarching bearing on what happens in other cases?
I mean, yes, I think it does. I'm not familiar with that particular episode that you're talking about. I'm sorry, I can't speak to that one. But if you're asking, do these litigation victories have an impact on how the agency operates? I mean, I think the agency can take one or two stances. They can try and isolate and deal with individual parties. But I think it's hard for them to do that, given that they've chosen, instead of issuing a regulation on cryptocurrencies, and have not done so since 2018, or when they filed against Ripple. They've never offered definitive guidance. So they're looking for these cases to establish the boundaries of their authority and the guidance that they're going to issue. So I think that there's a big incentive, to fight in court because that's the only place you're going to be able to influence what the SEC is doing. And I think you got a big potential for influencing what the SEC is going to do by fighting in court. I mean, that's I think the way it's going to have to work. The way it sometimes works in agencies that do these things by rulemaking is they issue a rule, and then the industry experts get to comment upon it. They write letters and they write briefs and they say, well, we think that this is a problem. We don't like this. And then a responsible agency will take those things into account and say, well, hey, we'll tailor the regulation a little bit. That didn't make a lot of sense for this boundary case or whatever. And that can do a lot to make things really safe. And I mean, if I were running an SEC-like agency right now, I would be thinking, what guidance can we give to everyone in the crypto community where they have some sense of what they're doing? My guess is they don't know where to draw these lines. They're just sort of hoping that the lines are drawn for them. So, that's again incentive to fight, because you can have a sense of where those boundaries ought to be drawn.
Right. What happens? Before we get, just what happens to the people? Yeah. So obviously a lot of people can claim that, hey, they were damaged over the past 2 years because of this court case of the SEC's action. We can look at the crypto market and say, well, the crypto, all the other big digital assets in the top 10 had massive movement. Obviously, there was over the past in that 2020, right as they dropped the lawsuit, everything ramped up. Even XRP was ramping up and just came to a dead halt when the court case came out with a claim that XRP is a security. Is there any action other than voting in new congressional representatives and a new president to get rid of the SEC chair, which doesn't seem to matter because the SEC is just following from a previous administration? What happens to the people? Is there anything? And John Deaton is representing 75,000+. Do they have any claim against the SEC for damages? I mean,
Yeah, I mean, they can't get any recourse against the SEC directly. They have sovereign immunity, can't sue the king unless he lets you. So no, they don't have any direct recourse, and it kind of stinks. I mean, it's especially bad when we've spoken about this before, but it's especially bad when this is an agency that's supposed to protect the public, and they're sort of dragging the public through this along with Ripple, and perhaps maybe even worse than Ripple, because some people are probably really suffering. They've lost a lot of money in places where it really hurts on XRP, and not because there's anything wrong with XRP. That's what's really frustrating about it. It's interesting. I mean, I think you see a lot of people involved in this case because increasingly people are finding that the political process isn't super responsive to their needs. And I think that this is an instance in which, right, like you're getting multiple administrations giving really poor guidance by, they're doing regulation by enforcement. It's not good. There's revolving doors all across the board politically, and I don't see any recipe for solving those problems. But you can make a difference in court, and maybe the people who are in court also need to be calling their congressmen on these issues and getting hearings on the SEC's action in Congress going too. Putting some pressure on them that way. I don't know. Again, that goes beyond my pay grade, but they've got to put pressure on their elected representatives as best they can. And maybe like we said, this is unprecedented. I'm sure that Clayton, when he authorized this action, was not expecting anything like this. And then the Biden administration kind of sleepwalked into it and seemed comfortable from an institutional perspective, kind of staying the course. But they're encountering a very different animal than they actually figured on. So that's I think encouraging. I think that should be encouraging to people, no matter how this comes out. That they can affect pressure and they can do things if they really put their minds to it. And we can do things in different ways, especially, John's got a huge following on Twitter, and that social community it's got a voice that has impact beyond just these court filings. People pay attention when there are a lot of people get together and really complain, in an organized way.
Yeah, so let's just end up too, and somebody would ask as in the chat about your Twitter. I have that pulled up as well, but this was something John Deaton commented on. He said this is a significant example of why Monday's library hearing was so important. The judge's summary judgment decision applied to all. The token was LBC sales violate the Section 5, but the judge stated that he will make clear that his decision does not apply to secondary sales and only on libraries. And that's when the judge had said to the SEC, and the SEC said they kind of agreed to it. Like, yeah, so then that's in the public, that's no longer a speculation. That's something they agreed to. And then this, Carl, this is your Twitter. Do I have this right?
Yeah.
By the way, I love that little... This right here is great. The SCOTUS death rate right there. It's like with this thing. So guys, I'm going to drop that in the chat too. So please go give Carl a follow. He's got a lot of great stuff there. But I dropped that too, and it'll also be in the what do you call it, in the comments. What is that, Jeff? The info down below, and YouTube anyway.
The description.
That's what it's called.
Go to the description.
We'll add it to the description there. But this is it right here. This is Cecere. PC, Supreme Court Appellate Advocacy. And I can't believe that time went by so fast. I mean, it seems like we were just started chatting, but I want to be respectful of your time as well. And we just hit an hour. So, Carl, listen, thank you so much for joining us. I think you provided an incredible lot of insight, especially with your wealth of knowledge, especially how it applies to the Supreme Court and everything. And it was really fantastic having you on here and meeting you. So I really thank you from Jeff and I for coming on.
I really appreciate it. And we'll see, as things progress, I'd love to come back and give you guys an update on how things go.
I'd
love to have you back.
Yeah,
I'd love to have you back.
Yeah.
All right. Awesome. Thanks, guys.
Yeah. And hang out for just a little bit as we, we'll just, as we go on live
in
here.
The green room again. Yeah.
We'll see you in the green room in just a second. But Jeff, anything you want to say before we get out of here? I know you guys had a lot of great questions. And sometimes you only have an hour, and Jeff had a lot of, and I had a lot of stuff prepared too. But I just want to say what's amazing about these folks in the chat and we call them the on the chain, family, just incredible. I don't know if you can see what the questions are, but just incredibly thoughtful questions. We could do a whole other show just on the questions inside of the chat itself, which is
just reading the questions and the comments. That's
right. Which is why we so much enjoy doing this live. Yeah. And thank you for joining us on a Sunday evening too. But Jeff, that's all I have. You want to say anything before we go? And then Carl, we'll talk to you just right before we turn the live off here.
Yep. Carl. Yeah. I appreciate you coming on. Thank you very much for that. Looking forward to having you back on to see the progress, and a big shout out to everybody that has joined us here because we do have the best, the brightest, the smartest in the YouTube crypto space that join us here. We'll check you guys out Wednesday evening. That's all we got. Carl, we'll see you back in the green room in a minute.
Great.
For our parting greetings, and that's it, Chip.
That's it, guys. So we'll see you on the next one. Thank you for joining. Take care.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.